Now that was the most basic way of dealing with estate tax issues. There's another way, and we call it a formula marital deduction will. And that's what this diagram tries to illustrate. Once again, we have an estate that's $2,350,000. Let's say, once again, it's the husband who passes away first. In the terms of his will, instead of giving everything outright to his wife, his will says, I want to carve out from my estate an amount equal to the Connecticut estate tax exemption. And I want to put that into a trust. And we'll call that the exemption trust. And once again, that trust is for the benefit of the surviving spouse, but it can be a much more flexible trust than the disclaimer trust that we just talked about. And we'll get into the differences between the exemption trust and the disclaimer trust in a second. But the point is, his will carves out the exemption trust. He carves out an amount equal to the exemption. His surviving spouse doesn't have to make any decision about that. It's done for her. And I forgot to mention, in the disclaimer trust, if the disclaimer is going to be made, it has to be made within 9 months after death. So I forgot to mention that earlier. But that decision needs to be made within 9 months after death. The disclaimer trust does not get set up until the wife actually makes a decision and does something proactive within 9 months after death. With this formula marital deduction will, the decision is already made for the surviving spouse. She really doesn't have any say about it. That $2 million is going to be set aside and put in trust for her benefit, and the balance will pass to her. So $2 million is carved out of the estate of $2,350,000 and put into the exemption trust. That's not going to be subject to tax because that's smaller than the husband's estate tax exemption for Connecticut purposes. And the $350,000 that's left over passes outright to the spouse. That's not subject to tax because transfers to a surviving spouse who's a U.S. citizen are not subject to tax.
On the other hand, many wills have formula marital deduction provisions that are based on the federal estate tax exemption. I was just talking about a will that is based on the Connecticut estate tax exemption. If the will is based on the federal estate tax exemption, however, keep in mind that the federal estate tax exemption has been changing. Actually, the Connecticut estate tax exemption has been changing also. It wasn't that long ago that the Connecticut estate tax exemption was $3.5 million, and it was reduced several years ago to $2 million. Anyway, if you have a will that is based on the federal estate tax exemption, then at your death, the will says, carve out the federal exemption and put that exemption into the trust. Now, how would that work in the situation we were just describing where the estate is $2,350,000? Let's pretend that this will was done a while back when the federal exemption was $2 million. At that time, if death had occurred in that year, $2 million would have been carved out and put into the exemption trust. But the federal exemption has changed over the years. Now, in 2016, the federal exemption is $5,450,000. In one more month, this update is being done in December 2016. The federal exemption will be $5,490,000 in 2017. So, you read that type of will, and it would be interpreted typically, but not necessarily, because it may create some difficult interpretation problems as well. But one interpretation, and this is the result that you would get with the wills that we draft, one interpretation is that all of the $2,350,000 would go into the trust. The will says carve out an amount equal to the federal exemption. And in 2017, that would be $5,490,000, and put that amount in the exemption trust. So, if there's less than $5,490,000 in the estate, then the whole estate will pass to the exemption trust. And so, as the exemptions have increased, and where the client has that type of will, it can have the effect of disinheriting the surviving spouse. So, That's what we mean in the yellow oval circle in the diagram there when we say beware accidental disinheritance of spouse as those exemptions increase. Effective on January 1, 2011, Congress enacted a provision which has the potential to change a lot about estate planning. These provisions were scheduled to expire on January 1, 2013, but early in January 2013, Congress made these provisions a permanent part of the federal estate tax law. Congress enacted a unique provision, an innovation, that was effective January 1, 2011, whereby when one spouse dies, leaving a surviving spouse, the deceased spouse can actually give his exemption to the surviving spouse. So what that means is, if I have a federal estate tax exemption of $5,490,000, that's the 2017 exemption, but I have zero assets, and if I die first, leaving a surviving spouse, then I can give my surviving spouse all that $5,490,000 exemption. That means my spouse, when she dies, will have her own $5,490,000 exemption plus mine. So that makes an exemption in my surviving spouse of almost $11 million. So as you can see, that's very favorable. This table is giving you information that you've already seen in other tables. The information is just presented in a different way. You can see the words portable very prominently in 2011, 2012, and 2013 for the gift tax exemption and the estate tax exemption. And all these exemptions have been increased so that in 2017 there is an exemption of almost $5.5 million. When we use the word portable that's seen in the table, what we are really saying is that one spouse can give the surviving spouse his unused exemption. So you can see the effect of that. Here we have a situation where we have a client with a simple will. In this case, the husband only has $100,000, and he dies in 2012 and gives his $100,000 to his wife. So obviously his 2012 exemption of $5,120,000 is not used. Now, because of the new portability provisions, he can give his $5,120,000 exemption to his wife. His wife has an estate of $8 million, augmented by what she receives from her husband. Her estate, after her husband passes away, is now $8,100,000. Before this portability provision was enacted, a plan like this would have resulted in the husband completely wasting his exemption. As a result, later on, when the wife dies in 2013, the U.S. estate tax on her estate would be $930,000. But because in 2012, when the husband died, he could actually give his exemption to his wife, when she dies, her exemption is not just $5,250,000. It's augmented by her husband's exemption, which was $5,120,000. She has an exemption when she dies in 2013, which is over $10 million, and her $8,100,000 estate can all pass to the children free of the federal estate tax, but nevertheless subject to the Connecticut estate tax.
So I've amused myself on occasion thinking about the planning possibilities here. And one planning possibility is for wealthy elderly bachelors who are thinking about estate planning, looking for a mate to marry. And the ideal mate would be one who has absolutely no assets and who has a very short life expectancy. And this slide represents a new business, which I expect somebody will think of and actually try to market. We mentioned before how the disclaimer trust does not protect assets from the claims of creditors, and in particular, we might be considering costs of long-term care. Now, I also mentioned that instead of an I love you will, which is the will that gives everything to the surviving spouse, and then when the surviving spouse gives the assets to the children, instead of doing that, the husband could have put everything into a trust that would be designed to protect the assets from the claims of the spouse's creditors and would be designed so that the assets of that trust would not be counted as a surviving spouse's assets when it comes time to apply or pay for long-term care costs and perhaps apply for Title 19. So we just wanted to make certain that you understood that this asset protection, we call it asset protection bypass trust type of will, is available to protect some assets from the claims of creditors and the costs of long-term care.